We have a couple, one big news article to kind of really cover today for the first half of our show, going over the outcome from the Court of Claims regarding temporary operators, Laura's reaction to that outcome, and what we can expect over the next few weeks for temporary operators, patients, caregivers, etc. We're going to start the first half of our show going through that case and what we can expect. And depending on how much time we have left, we're also going to be touching on a lot of intellectual property topics that are going to affect cannabis licenses. So let's get right into it, Nick. Today we're going to talk about the temporary outcome, it is a temporary outcome, the temporary operator outcome in Green Genie et al. Versus State of Michigan. So what exactly happened?
So as you kind of have been keeping up on, the temporary operator saga continues, and yesterday we kind of received somewhat of a temporary but more concrete resolution on the issue. Temporary operators, basically, just to make a long story short, if you satisfied certain criteria, local approval, submit an application by a certain date, you would be allowed to remain open while your application was pending. There were deadlines established that kept moving, and eventually this is what ended up creating the lawsuit that was heard by the Court of Claims. A few of the temporary operator applicants had sued the state and Laura, arguing that this process and the deadlines and the different criteria that kept moving violated certain due process rights that they had. And eventually, going back and forth, we ended up hearing, I know Judge Borello of the Court of Claims heard the case a few weeks ago, I believe, and had expected to have his ruling by last Friday.
Got pushed back a few times.
Yeah, and so it ended up coming this Tuesday.
Yep. So on April 30th, we did get an opinion and order which effectively ruled that these temporary operators had the right to remain open as they both had their applications continue to be pending, as well as appeal any potential denial that they received. It was quite the opinion. I think the obvious and most direct impact that had is anyone that has that temporary operating status gets to continue open until they exhaust their appeal options. But there's some other interesting outcomes of that as well. So first, how did we get to the conclusion? What did the judge basically determine as the reason that they could exercise these appeal rights?
Right. So what basically happened was that the applicants argued that these decisions, as I mentioned, violated due process. And so, without getting too legalese on everyone, there's language in the U.S. Constitution and the state constitution that says the state can't deprive you of life, liberty, or property without due process of law. And there's two different types, but basically they were saying is that, these decisions were arbitrary. We had a protected interest in this property right or this benefit that the state was offering to us. And these decisions that were made and how we were treated offended those notions of fairness and full opportunity to be heard, and only getting that denial after you've had a full opportunity to have your case or your application heard. Right. So basically that's how we got here. And again, the ever-changing shutdown dates, and I think that the way that the argument was the way that Laura was reviewing the applications and the time it was taking them to do that kind of all added together to make this, an argument related to due process. And
so, and I think that's the main takeaway from the conclusion the court arrived to. While the direct impact is for those temporary operators, those few businesses that are still appealing those denials or still waiting for their application to be heard, it also sets a really good standard for applications in general. There was a section of the statute from the Medical Marijuana Facilities Licensing Act that basically says, this isn't a property right. You have no interest in or protection for this license if you attain it. And the judge basically threw that out. He said, you receive a benefit. This is a property interest, which means you have a due property protection for, making sure that your interests are protected should you obtain it. And I think that logic is going to be something that we can utilize in a lot of situations moving forward for any type of license holder. A lot of, not only the state law had that right in there, but most municipalities will put into their ordinance that, if we issue you a license, we have the right to take it away. Or it's, you have no ability to treat this as like a non-conforming use or some other appealable due process protected approval that you get from them. And the judge basically is like, well, that's incorrect. you clearly get a benefit, and that benefit is determined to be a property interest. And while it's not going to immediately throw out any of the language in any of those ordinances or other laws, it's the legal logic that the judge concluded that we can basically use, as the foundation of challenging other laws in the future should we need to. If a municipality gives you a license or a permit to operate, and you do nothing to violate the rules, or they change the rules on you to make it impossible for you to maintain that license, you have a great argument put together by the Court of Claims that you can use to, basically start your appeal of that issue.
Right.
So, long-term implications of this conclusion, I think, are going to be more useful for the industry overall, but the obvious short-term implications are very, interesting as well.
Yeah, and I think that was the biggest thing that, the state was arguing. These plaintiffs, these temporary operator applicants don't have an argument. They can't even bring this case in court. The reason for their argument was that section that said this license is not a property right. If they didn't have a property right, it couldn't have been violated. Their due process rights couldn't have been violated, since life, liberty, or property. If you don't have a property right, then by way of reasoning, that can't be violated. What Judge Borrello said was that even though that section of the law said you don't have a property right, it passes the smell test or the sight test. You know it when you'll see it. There were rules, requirements, notice, hearing, appeals. All of those things were kind of wrapped into one, despite the fact that it said no property right. So even though it's labeled as not a property right, the court concluded very reasonably that it is.
Right.
And so that's just another kind of sentiment where it can say one thing, but really when you look at it, it's not just how it's labeled, it's what it really means, what it stands for in reality, in practice.
Right. So the opinion and order came out on Tuesday. On Thursday, the Marijuana Regulatory Agency, or LARA, came out with a response, basically saying that they're going to be reviewing the affected applications with great haste, swiftly providing, approvals and denials, and ensuring that those appeals, move forward, as quickly as possible. We want to state, Cannabis Legal Group, regardless of the situation, overall, the MRA, a Marijuana Regulatory Agency, the agency that has been four names at this point, their job is to, implement the law as they determine it. So, their outcome is what it is, and they're handling with grace the path forward here. There's some other things kind of coming down the line that might impact temporary operators. Again, what are some of these pending bills in the legislature now?
Right, yeah. So before we go there, just one thing I wanted to mention too.
Sure.
About the MMFLA license. So not only did the judge conclude that an actual MMFLA license is a property interest, but also the provisional licenses that the temporary operators were operating under were found to be a license type. And there's, Administrative Procedures Act that says if you have a use and it's a new application, you can't just deprive it without a full and final opportunity to do that.
So for those of us non-attorneys, that's why I didn't go there. So the temporary operator is technically operating under a provisional license, not the type of license a fully licensed business is going to have. Either license has the property interest the judge is describing.
Yeah. So he extended it enough to allow him to conclude that way in favor of temporary operators, that it was an arbitrary and capricious random decision, according to the court, that offended those notions of fairness and due process.
Exactly.
To go back to Travis's question about the kind of bills that are pending, is House Bill 4440. It was passed by the House. To my knowledge now, it is in the Senate. That can also come into play along with Lara's advisory bulletin that they will be swiftly deciding the applications. But what this potential new law will do, in addition to, we've reported on this before, but it's, it prohibits you from applying for 1 year if you hold yourself out as a licensed facility.
Well, let's stop on that and explain what that means first. So if you are acting as a business that would need to hold a license, and you get caught doing that, then you are prohibited from applying for the actual license for 1 year. Right?
Yeah, so in addition to doing that, basically they kind of did a carve out for temporary operating facilities, saying that, the board or the agency can't hold it against them if they continue to temporarily operate. Part of the judge's holding was that there's an injunction. Basically, the state and Lara are prohibited from enforcing or shutting down these temporary operators or facilities that arguably, are not having a license until 60 days after a final agency decision. Now, what that means is that not only, now Lara is going to be reviewing these applications and issuing decisions, you still have an opportunity to appeal that and have a public investigative hearing with an administrative law judge. And so basically what the judge's ruling is that after that administrative law judge then has to send it to Lara, and Lara has to issue its final decision whether or not it was right. After that decision, and it gets mailed out, 60 days after that is when that temporary operator would have to shut down. So there's kind of a timeline and a timetable for how this is all supposed to play out thanks to the judge's ruling. It's kind of more clear now going forward, to ensure due process is respected. This is now kind of the way that the process is going to go forward with temporary operators.
Exactly.